Hey everybody, Todd Vandermeid back for another edition of Freedom Steel. Sorry it's been so long, but let's start off with a belated Merry Christmas, Happy Holidays, Happy Hanukkah, and a wonderful New Year. But we've got some big news yesterday from the Supreme Court. So, did the Supreme Court just tee up a grand slam for gun rights? More after the intro. Hey everybody, Todd Vandermeid, former NRA contract lobbyist, Illinois gun law guru, the gun Santa or tactical Santa, depending on which Reddit forum or Twitter you're chasing down. So, anyways, big news yesterday, Monday, January 6th. The Supreme Court announced that it has distributed for conference several Second Amendment related cases. Now, mind you, a couple weeks ago, the Supreme Court had put Gravy Jennings on for the Friday conference on January 10th. That case deals with what are the appropriate standards when a challenge under Second Amendment grounds is being put forth for an preliminary injunction. As you know, a lot of the lower courts have sat there, and sometimes we've gotten an injunction, and then the appellate court overturns the injunction, just like they did here in Illinois. And so they say, well, you're not likely to succeed on the merits, or whatever BS reason they do, because typically, if, like when Illinois passed its gun ban, the status quo would have been no gun ban. But the lefties and the anti 2A guys in the courts don't like to see any of that stuff held up. So we lose that. So it's an indirect Second Amendment case, but it's important because it started to tee up a narrative of what's going on at the court. And so yesterday we'd been watching the Snope case, which used to be Bianchi. It is the challenge to Maryland's semi-auto ban case. And so yesterday that case got distributed for conference this week, Friday. They also distributed Ocean State Tactical, which is a magazine ban. All right. And then the third one that a lot of people missed was they also did Maryland shall issue v. Moore, which Maryland has a FOID card esque type permit to purchase and possession for handguns, and they distributed it for conference. So you have a potential challenge to possession and permit to purchases. You have the semi-auto ban. You have the magazine ban, and you have this. What's the standing for obtaining an injunction or a preliminary injunction when you make a 2A challenge to a gun law? Four pretty significant cases for us. The question in my mind is that, the Supreme Court for a while didn't take a gun case. We had about 13 years between McDonald and Bruin. And then we had, Merrick Garland raced Rahimi up there to put the worst set of facts on our side up there. So all the stuff that, if you'll remember, Clarence Thomas, Justice Alito, they were putting out, comments on denials assert that, the Second Amendment was continuing to be treated like a disfavored right or the redheaded stepchild or whatever. And so the question is now, what does this all look like? Mark Smith, a guy who's a Supreme Court lawyer, much smarter than I am on all this kind of stuff, but Mark has been saying that, a relist for us coming up next week would be good because he explains that Justice Roberts, the chief, likes to have the clerks go back over all the case law and make sure that there's no procedural issues, no whatever. Okay, so on Monday, typically They issue the decisions from their conference the following Monday. So conference is on Friday. And it'll be a long weekend, and then we will sit there and twiddle our thumbs until Monday morning around 10 o'clock when we should see an orders list posted at the court. And then we will get the opportunity to see. If they just took the cases, the one thing is Snope and Ocean State were slated back in December for conference, and then they were rescheduled. They were pulled and they were rescheduled, and yesterday they issued that rescheduling for this week. So the question is, could they have already done all of the preliminary work that Justice Roberts normally asks after a tentative vote for grant is issued? Have they already spent that break from the reschedule to sit there and do all the legwork and flush out everything? Now the two Maryland cases, Snope and Maryland shall issue, both have been to the court before, and both were GVR'd after the Bruin decision came back. And in both cases, the Fourth Circuit Court of Appeals got it completely wrong. Just completely, ignored everything and made up out of whole cloth these new arguments that, AR 15s are not arms as defined by the Second Amendment. That's wrong. And that, they just kind of bootstrapped up a bunch of bogus issues to make their permit to purchase, their handgun license legit. And essentially, they're bootstrapping up that footnote 9 from Bruin talks about shall issue permits and mentioned 43 states. Well, 43 states have carry permits, 43 states don't have, handgun or FOID type licenses. So this could all be very, very big. Guys are going to sit there and say, well, Todd, how does this apply to Illinois? First off, in an inverted position, if they take the Moore case on the Maryland FOID card, then if we prevail on that these permits to purchases, so that would likely mean that no, Illinois' FOID card is unconstitutional, and that would send a pretty big shot through the Illinois legislature as far as the implications of that, what gets salvaged, what doesn't. The question would be, how soon does that go through? You already have a court case that had oral arguments in the 4th District. In state court, it would be interesting to see how fast, the Attorney General would say that it applies. My bet is the Attorney General is going to say the Illinois FOID card is way more comprehensive. It's so different. Therefore, this doesn't really apply. It depends on the language that the Supreme Court would use in the Moore case. Now, rolling up the gun and magazine stuff, hey, we have Viramontes, which was argued at the 7th Circuit Court of Appeals. And my thought is that if they grant Snope quickly, then I think that Viramontes will be put on hold. Chief Judge Sykes of the 7th Circuit Court of Appeals was on that panel. You've got Easterbrook in charge of the Southern Illinois case, that new panel. With St. Eve being added to that panel, she was also on Viramontes. I would think that the Illinois gun and magazine cases would go into an abeyance and be waiting. I would probably say that even though Duncan's been held up in the 9th Circuit, that if the Supreme Court decides they're going to do a full-on hearing on magazines, that that Duncan and the 9th Circuit, everybody's going to put everything on pause, likely, as they wait for the Supreme Court ruling if they take these cases. Now, if the Supreme Court rules that semi-automatic rifles, shotguns, and the like cannot be banned, They're in common use. I would expect that Illinois would then make a bunch of procedural arguments for other parts that are within the bill. The trigger stuff or trigger activation devices that are in the bill, that's still constitutional. I think that's what their argument's going to be. I think they will argue about the registration scheme, even though Judge McGlynn, St. Stephen, found the registration scheme unconstitutional. I think that they would probably we would probably get a remand out of the Seventh Circuit back down to Judge McGlynn for you know ruling in light of whatever comes out of Snope, uh, Ocean State, and on that issue. So that's what I think is going to happen if the Supreme Court takes these cases. Now, if the Supreme Court doesn't take these cases, then I think that we're in a whole different ballgame. I don't want to pontificate too far down that road. I don't think they're waiting for our Illinois case, although our Illinois case is broader. The record is deeper. There was a style of litigating some of the semi-auto stuff a while ago. Viramontes was a classic example of it, of where people, it's like, hey, let's just lose fast, get up there. We don't have to build a huge record. It's all in the law. And that clearly came out by the judge's frustration in the Viramontes orals. But so big day yesterday at the Supreme Court. Friday could be an even bigger day as they cast their votes. I mean, 2A relay. I mean, you got 3 solid 2A cases. A fourth one is tangential, but it's how we're getting screwed on the injunction process because they very rarely want to issue injunctions on our issues, making up all kinds of BS reasons why not. So, are we teed up for a grand slam at the Supreme Court? I think that since Moore and Snope have already been there before, and they were GVR'd post Bruin, and I think it would be weird for them, but not out of the realm of possibility, to GVR, say Moore, post Rahimi, and say, try again, you didn't get it right. I just don't think, I don't think they're in that mindset. I think at a certain point in time, the chief, they have put a whole bunch of this stuff off. They put it off for over a decade. They let the lower courts run roughshod over Heller. And don't forget that right before the new year, the chief judge issued his report on the court, and the left-wing media went bananas about this. And the chief judge there had some comments about, whether it be Congress or other people thumbing their nose and ignoring the court. And I took that not so much as Congress or even, President Biden sitting there thumbing their nose at the court. I took that more as like Hawaii, the Hawaii Supreme Court in their Aloha decision. I took it more as some lower court judges. So the real question is this the time that they are going to just say, we gave you 15 years, you still can't get it right after we've told you multiple times, so do they put their foot down? Does this become, I think that if they're trying to manage the issue, if they put their foot down in clear, concise, and emphatic ways, that could very quickly shut off the number of cases they're going to see, because the lower courts, the appellate courts, would be, say, here, we told you, do this. And then I think after that, some of them will fall in line. I think a couple of them, they've pushed it about as far as they can push it. And if we get a couple more rulings that clearly delineate certain things, I think a bunch of those lower judges, because then I think if they continue to just ignore the court, then I think Jim Jordan and the Senate Judiciary Committee with Grassley certainly have some room for investigation on judicial malfeasance and misconduct, and whether or not there should be impeachment proceedings beginning on judges. Very dangerous road to go down, but hey, as always, thank you very much for watching. Please like, subscribe, copy, paste this link around, share it with your friends and everything. I'll have some more to say now that the new year's here. For everybody that's inquiring, my wife is doing much better. Things are getting better and all that. And I got a couple other topics to talk about. So, hey, as always, frag out.